All right. Short and sweet today. All right. Just a couple of hoping to do 3 videos now. We'll see how things go. Let's keep it rolling here. But number one, we're gonna finish out where we are with bias on DeLaO and Petrasek. I guess we can get into some brief discussion on where I am with that, with Mullenbach, Petrasek, and Zakard, and we'll try to get all that together. I want to talk about Matt Chasen for sure, and then I've got a couple other things that we'll get onto. So that's my exciting adventure for today. I am absolutely behind, got stuff to do. Most importantly, my wife is now in Denmark, which is pretty exciting for her, and I am manning the fort, as it were. And it's a full morning, let's say, but everybody's off where they need to be, and we're getting things going. I have Honey the dog, which I'm not going to bring her up. I feel that she'll bring herself up at some point. We are sort of going through the grooming rotation, but Honey is my daughter's favorite, so Honey is here for my daughter and in absence of my wife, among other things, sort of like Nana the dog from Peter Pan, if you follow me. And yeah, it's all right. She is way more of a barn dog than even Lala. And Lala, by the way, was just completely inconsolable when she couldn't come. And Honey did, but boy, did Honey need it. We got the coin-operated dog spa, so that was phenomenal. And yeah, our lives are not totally a big fluffy mess yet, a big fluffy white mess, I guess I should say. But we're moving there. So good morning to everybody. Let's rock and roll. All right. So if you remember the last time we were talking about sort of prejudice here and bias, and we were talking about the difference between that here. This section is entitled The Secret Conflict. So we're talking about a conflict of interest, which is prohibited for an attorney to have under the Supreme Court rules. And then we're also talking about a bias in and of itself. So those are two separate things. Bias is a is a due process violation. Let's look at that. I was going to say 14th Amendment. But bias in itself, unacceptable bias, put it that way, is a due process violation. And if a judge is found to be biased in any tribunal, particularly a court tribunal, then that is problematic for due process, and the whole thing has to be thrown out. But when we're talking about a conflict, that's a separate issue for an attorney and the Supreme Court rules. So we went over the Supreme Court rules of ethical rules for an attorney. Remember, administrative law judges are really hearing examiners, and they're just by courtesy called administrative law judges. So they do not fall under the Judicial Code of Conduct. They fall under the Supreme Court rules for attorneys, because by rule, they all have to be attorneys. I don't know that that's a law anywhere, but I do know that it's a rule, meaning part of the job description. So that's where we come up with that. So now we're going to talk about bias here, and remember the key factors on that. There's like two kinds of bias, basically. There's automatic bias, and then there's situations which can create bias. So automatic bias which is, almost never happen. These are known relationships that throughout history have put somebody, given rise to an unacceptable uneasiness, okay? And this is the key thing to understand about bias is this, okay? And because it's a little bit tricky, there's two sort of hurdles that you have to jump over. Number one, you need something more. You need some kind of evidence, okay? So that means that you can't, remember we talked last time, um, a judge and the defense attorney go to the same country club. That doesn't mean that the judge is automatically biased, because they have a presumption that they're not biased, okay? So that means, what does that mean for you? You have to get some kind of evidence to rebut the presumption of non-bias, okay? But you don't have to have conclusive proof to have a finding of bias. And what does that mean? That means that, like, unlike guilt, you don't have to have a smoking gun or a picture of a judge, heaven forbid, taking a sack with dollar signs on it. Okay, that it doesn't have to be the case. So what you need is more than just a simple connection, more than just routine everyday behavior of judges. And remember, judges are the ones going to be judging the judges. So you have to keep that in mind. What may be outrageous conduct to you or unacceptable may not be the same for judge to judge. That's what you have to keep in mind. So those are the two sort of standards here. But if we ever get in the phrase that we use in Wisconsin, it's slightly different around, anybody's watching the Grizzly True Crime stuff on Delphi. This is where that really comes up. But other podcasters are definitely talking about bias here. For judges, it's the same sort of issue of what's happening with the clerk in the Murdaugh case. Does that raise the unacceptable risk of bias? So we said here in Wisconsin, it's an unacceptable risk, meaning, again, you have to show that it's unacceptable bias, but you don't have to prove that, again, the judge took money from them. You would have to show that this is the kind of relationship exists, which is beyond the normal, that one would tend to think there's a problem. So that's that unacceptable risk here. Again, the categories that are automatic are blood relationships. Sometimes that's defined more narrowly than others. But everybody seems to agree that brothers, mothers, children, things like that, direct blood relationship, no question about that. Because some people think that cousins are definitely in, and that runs the gambit. Now, again, there can be other things that you can do, for example, to criticize the judge, not in the courtroom, because that's contempt, but to criticize the judge, other circumstances, possibly running an election versus that judge. That's, again, the form of criticism, you might say. Let's say the judge is a direct participant or even a witness in the situation. So the judge witnesses the car accident, can't be the judge of the case. The judge, it was in the, a defendant in the case, automatically can't be in the case. Okay. Pecuniary interest. So there's a lot of these cases that go on and say, hey, the mayor was getting the speeding ticket money was going to the mayor's personal account. The speeding ticket money was going to the police department's pizza fund, which the mayor oversaw. Along those lines. Okay. Also can be, for example, there's a line of cases that say, hey, you've got a job here. You want to keep your job. If you do this action, you might not keep your job. People are going to be worried about that. Okay. Now, again, is it enough to say so-and-so is employed by somebody else, therefore they're not going to be a judge? Well, another one to look at that, as we say, is a business relationship, and that one's automatically out. So if the judge has bought stocks with the Coca-Cola company and it's you versus Coca-Cola, you're not going to feel that hot about having that judge on that case. So those are, again, some of the examples. That's how we a lot of the way we understand where the rules are in law is by examples from other cases. That's why we read them here. And once again, here I am off on a tangent with little old me and the big facts on the screen. So let's, with all that in mind, we're going to sort of re-look at this last couple of words in this paragraph here and then go from there. The administrative law judge is also now aware that the email mentioned in the complainant's complaint was Respondent's Exhibit 27. The email, let's be clear, her talking about Petchacek and writing Carr about the fact that she thinks him and Petchacek are biases in the actual complaint. It's very significant, and the ERD traditionally has held this to be a completely different standard of everything when something is held to be in the complaint itself, especially in terms of relevance. They sometimes have a really hard time figuring out something's relevant. But if this email is specifically mentioned in the complaint, that's a big deal. Which mentions Petchacek only as someone who received an email and passed it on for investigation. See, that's just false. It specifically says that she being Novak, does not want Petchacek or Carr to be having any part of this decision because he made these statements to the inmate group, and he believes that she is his right-hand man. So that's my recollection. You want to go read the testimony, you want to go look at, and you got something else, let me know. But that statement is not accurate as far as based on my recollection. Only as someone, and I feel like that took some work. I'm a little bit, it failed some work. It is okay. Here's a key fact to keep in mind. I put in an affidavit that we were not aware, and see, she's trying to put it that we're saying that it's a complaint. Now, the fact that we put Petchacek's name or an email that contained her name in the complaint is not the same thing as saying that I was aware or the complainant was aware that Amy Petchacek is the same person whose name is on the ERD decision. Those are two separate things. Awareness that one person that she was the deputy secretary of the DOC is not the same thing as awareness that she is now currently the secretary designee, because the Republicans never approved her of the Department of Workforce Development. That does seem a little bit odd if somebody can be through 2 terms of a administration and a secretary designate. It doesn't seem to be, I don't think that would fly under federal rules, and that seems to be problematic, to say the least. But hey, what do I know? So, since the complainant was aware of all these things, now let's see, does it say that the complainant was aware that Petchacek was the head of the DWD? Position that Petchacek and DWD. Okay. So, and again, if you can show me some fact in the record that says that I knew that it's the same Petchacek was the head of the DWD that was formerly from the DOC, let me know. Okay? If you can show me that, let me know. But I don't recall that. I recall signing an affidavit saying that I was not aware of that until I signed this, the motion here. So, that's, as we say, facts, not in evidence. But again, it's absolutely, a judge can decide that the light was red, yellow, or green. A judge cannot decide that a stoplight was blue unless there's evidence that supports that conclusion. That's the key fact here. So, let's keep going, because again, it's my contention that that's a false assertion and it's erroneous exercise, as we say here. It has no basis in the record, so she cannot make that decision even if she wanted to. Now, here again, it's nonsensical to say that the administrative law judge should have pointed out to the complainant that the 2 positions that Petchacek has held that possibly touched on the complainant's case, since the administrative law judge did not know about Petchacek's possible role, but the complainant most certainly did know. Why this is amusing to me is because this is parallel reasoning. And we can say that this reasoning is exactly parallel to Carr's and Fesahayi's reasoning of why they're not responsible for the fence. Exactly, Peril. I didn't know. You knew. I didn't know. It's your fault. That's what that is. There's several reasons why that doesn't fly. First of all, because it's factually inaccurate. But second of all, it doesn't matter. Miss Novak is not the administrative law judge. Miss Novak is not an attorney with potential conflicts of interest that need to be divulged. Miss Novak is not an attorney required to, let's say, be candid with third parties. She's not. So if anybody can show some evidence that says that I knew that, for example, Petchacek, the DOC secretary and the DWD secretary, the same person, before this hearing, then we're in a different situation. But it's not possible. It's very possible to say that this judge knew or should have known, and she admits that she knew as of the first day of the hearing. Given that the complainant knew of Petchacek's roles as the DOC deputy secretary and the DWC secretary, it was the responsibility of the complainant to raise any conflict of interest issues that the complainant believed arose from the situation in a motion before the motion deadline, at least before the hearing itself. And preferably as soon as the complainant had the concern that there was a conflict of interest. Okay. If the complainant had made such, which is exactly what I did, if the complainant had made such a motion, which is exactly what I did, then the parties would have been allowed to brief the issue and a decision could have made before the 6-day hearing was held. Conversely, if you had alerted us as soon as you admitted it, this is the key fact. There is facts on the record that says that she knew about it on the first day. There's no fact on the record that says we knew about it on the first day. That's the key distinction here. The light can't be blue. If the parties briefed the decision before in the present case, the complainant failed to mention the complainant's concerns about a conflict of interest issue, both bias and conflict, to the administrative law judge until the complainant filed an early initial post on June 6th, apparently forgetting that the due date for the initial brief had been extended until June 20th, 2023. Well, what actually happened is that I was preparing to do this work because that's when I was free for it around before she extended the deadline, and that's when we learned of the secret law and the Petchacek facts. So we just decided to file everything. If there's any secret about an alleged conflict, it was a secret that the complainant kept from the administrative law judge. Thank you, Julie, by the way, for getting us to that second mark there, where she does seem to look around for several seconds, clearly realizing what's going on. So, that's astonishing. Let's keep in mind that why did Mr. Mullenbach, who obviously had to know that who Petchacek was, because they were clearly consulting with her and checking with her as a witness. That's my belief. I do have some background information on that, but it could be that that's not the case. Be careful if you only have one source, right? Okay. So the point is that why doesn't Mr. Mullenbach have that issue as well? Well, he doesn't have to disclose because he doesn't have the conflict because his boss isn't Petchacek. That's the distinction. Now, you could say from the reading the rules there that it's a third person and he should have divulged it and so forth. Well, then you get into that it is a adversarial process and a conflict. We're trying to beat each other. Now, should he be able to hide that conflict and so forth? I think that's a bigger question there. But generally, when I speak to the experts on this sort of subject here, the thought is that Mr. Mullenbach doesn't have the same issue that the judge has, because again, it's who actually has the conflict, right? It's not if Mr. Mullenbach knows that the judge's mom is. It's hard to say that sentence out loud. It does seem kind of troublesome. I don't know there. We'll have to look into that. But this statement in itself is not a statement that you would hope from an adult. If there was any secret about an alleged conflict, it was a secret that the complainant kept from the administrative law judge. It's your fault that after I never said anything after the first day. It's your fault. Having heard the case at hearing and reviewed the exhibits, the administrator finds no conflict of interest because Petracek was the DOC deputy secretary during the time. This is not the right analysis, first of all. The term is not conflict, it's bias. She's clearly doing a bias analysis, but it's not clear if she understands that it's wrong or what. But it's the don't let the word conflict fool you. There's no question that there's a conflict. The next question is there an unacceptable standard level of bias here? So I will just reread that. The administrative law judge finds no bias because Petracek was the DOC secretary during the time covered by the complainant's complaint, and because Petracek is and has been the DWD secretary designee since the complainant filed a complaint in this matter. Despite being aware of Petracek's positions at the DOC and DWD, the complainant never made a motion. Again, you have no evidence of that. And in fact, I signed an affidavit completely to the contrary. So that's completely unacceptable for her to say that. That's why, by the way, for situations like this, because how am I supposed to know that these two people are this two people, same person holding two different positions? It's not my job to know that this person's the witness's name is on the judge's paycheck. It's the judge's job to know. And even if I do know, the judge has to still disclose that for the same reasons. All right. This is so it couldn't be my fault because despite being aware of the complainant never made a motion prior to June 6th and need a brief to claim that there was a conflict of interest because of Petracek. The complainant never listed Petracek as a witness. During the testimony in the matter, the complainant focused on Carr and to some extent Fesahaya as the persons who made decisions to the complainant's claim and her complaint and who allegedly discriminated against the complainant because of her sex. Petracek was never mentioned other than in passing at the hearing. Well, I think that's all you need to say right there, but okay. While the complainant mentioned Petracek in her pre-disciplinary hearing statement, this was in connection to her... Wait. Complainant's emailed to Petracek, showed an email was sent to Carr by the complainant to support the complainant's position, was emailed to Petracek without comment, and that Petracek forwarded the email to Christy Preston without comment. Sounds like something a little different's going on down here. All right. While the complainant mentioned, that Petracek would not be independent if Petracek replaced Carr in making decisions regarding the complainant's disciplinary investigation. Specifically, the complainant thought that Petracek would follow Carr's lead if she replaced Carr and fire the complainant to satisfy an advocacy group who was angry that the complainant had ordered a lockdown of CCI in November and December of 2019. The complainant's mention of Petracek in the pre-disciplinary hearing statement shows that Petracek was not a decision maker in her disciplinary investigation. The testimony shows that Petchacek was the direct supervisor of the internal affairs investigation. Chrissy Preston. All right. That now we finally get the whole theory here. It's too bad we didn't get it up above, but we finally get that in there. That's just what she thought, though, so she's like totally wrong. But we're going to use what she thought, not for the facts, but to prove something that the judges and shouldn't have known. Okay. Complainants mentioned, and the test isn't whether or not Petchacek was a decision maker. Because, for example, there could be a bias for having her not look like someone who participated in discrimination. Just for example, that could just be a reason that somebody might not want a high government official there. So it's not only somebody just for their credibility. It's not only the decision makers. What she's saying there is it's not impossible for DeLaO to be biased because Petchacek wasn't a decision maker to terminate Novak. Explain to me how that has any basis in the rule. You also notice that she hasn't established what the law is. You can guarantee yourself that if we filed the motion, it would have had what the law is on bias. You can guarantee yourself on that. And we could read it now, but for the sake of brevity, we won't. Okay? So we can know that she had access to somebody else telling her what the law is, or she has the ability to do that work herself, for example. And we do not see any statement of the law on either what conflict of interest is or bias. So let's just keep that in mind when we look at that. But then just these statements here, that's also why these statements here are completely unhelpful, because whether or not Petchacek is a decision maker is not determinative of bias in any sense. That's simple fact. Because, again, the question is, it's not only if bias would not happen if only the judge's brother was the driver of the car that hit you. There could be other situations in that, or other facts within that scenario that would render the judge unable to help you. Just for example, let's say that the driver who hit you ran a light and said it's green, and the passenger, Amy Petchacek, also says the light's green. And the judge happens to be getting paid by Amy Petchacek, just for example. That seems to me to create an unacceptable risk of bias there. If that's a different scenario, let me know. But that's what I got from that. All right. Here we go. The administrative law judge finds no evidence that Petchacek was a decision maker in the suspension and investigation of the complainant at the DOC, and there's no evidence that Petchacek played any role in the complainant's decision to retire from her employment at DOC. That sentence does not align with the previous sentence that we just read out. No evidence played any role in the complainant's decision to retire. And then we're talking about an email saying that they wouldn't be. And she's the head. See, we had this before, and we'll get into this here. But I guess that's what we'll leave it for right now. But do you tell me if this email and the fact that Petchacek is the supervisor of Christopher Preston is synonymous with There's no evidence that Petracek played any role in the complainant's decision to retire from her employment at DOC. I don't know. I don't know. As you can tell, I'm a bit astounded there. I mean, I think to come to that conclusion, you have to do this kind of heavy lifting here, but it doesn't meet. It seems to me to be the barest of heavy lifting, meaning it just doesn't seem like she's even trying that hard, in my opinion, to make a good case for why this is not a conflict of interest or bias. I think she just merely asserts that it's not and expects us to go about our business. So I don't know that that's happening, but we'll go from there. All right, stick with us as usual. The music doesn't last as long as I'm talking, but that's how we keep you informed. Take care.